Hi, Bill Hanshaw here again, your friendly local constitutional kook. And at the outset, I want to please excuse my informality today, but the weather conditions being what they are, just somewhat northwest of the equator, it's been an interesting. In fact, we've gone from October to July here, one fell swoop in about a week. That said, I got a couple of things to talk to you about, constitutional topics, as I always do. First one is an important one that people don't even think about. And if you do, it's simple math called ratio of representation. Comes under Article 1, Section 2, Clause 3 of the Constitution. 1, 2, 3, easy to remember. Okay, 1, 2, 3 pertains to racial representation as one of the few provisions of the Constitution dealing strictly with numbers, so simple that fourth graders will understand them, and yet with critical issues pursuant to the violations of our rights secured by the Constitution. But racial representation is yet another issue which, to any serious student of the Constitution, let alone a conspiracy theorist kook like me, which my decades of research have not found a single decision by at least the 9 old farts. What that means is we present questions like this, they're novel questions of law, and if you go by their rule book and their rules and their BS forms, novel questions have a much better chance to get heard there than any other type. Just a thought. That said, 1, 2, 3, a provision has never been modified, amended, or changed, and it would have to be changed by amendment, provides a maximum ratio of inhabitants to representatives of 30,000 to 1. Just a glance at the current population of the U.S. today at 325 million bears stark testimony as to the problem. With but 438 members in Congress, what is the factual foundation and legal basis for a valid determination of a quorum to do business when the House should contain about 11,000 members? I'd love to hear it. This makes the current racial representation close to 800,000 to 1, not remotely related to the Republican form of government guaranteed to the states, and not the Republican government at all. It's not how it works. And think about this. This works out to be very convenient for the New York banksters and their political activity committees that have all kinds of money to control this minimum amount of members in Congress, House and Senate both. It's more critical in the House if we had the members we should have, with local responsibilities and people that knew them and could get to them and express their opinions. That might change a lot of the ways that laws get enacted or don't, depending on what they're trying to do. Just a thought. Anyway, this issue definitely raises a key issue pursuant to the absence of a quorum to do business, most particularly in the House, which exponentially expands in importance when one realizes just how flexible, quote-unquote, a determination of a quote-unquote quorum to do business is based on the political expediency of the party in power at a given time. And the big issue here is that no quorum to do business equals no validly enacted laws. All we have to do is raise the issue, what the hell are they going to do? There was not even close to a quorum, and as you'll find out in the speech coming up, there's nobody in Congress right now, especially the House of Representatives. It's empty. No quorum. Even 3, and by the way, as far as I'm personally concerned, that they could get creative and say, well, we have 3 members of the House present, that's a quorum to do business, and go say 2-1 is quorum. As silly as that seems, that's exactly what the 904s are saying with juries. Not only do they not have to be unanimous, which is the common law rule, now the court says it's okay to cut them down to 6, and apparently a 4-2 majority would be sufficient to convict you. Why wouldn't 2-1 qualify there for a 14th Amendment citizen? Just a thought. Okay, racial representation is a big deal, going so far as to directly alter the outcome of the election of 1876 between Hayes and Tilden, since few, if any, adjustments in the racial representation were made prior to this election, which would have resulted in Tilden being elected. Racial representation is also an issue you'll learn about with the acquisition of my modestly priced constitutional defense document packets. Information readily available. Send me an email at youwinnincourt@gmail.com. I'll get right back to you about that. Happily, as it were, for us, this situation has been in existence for well over 100 years and brings along with it all of the unopposed constitutional issues I advocate, any one of which is sufficient to establish the absence of jurisdiction of a trial court, and none of which can be answered. Indeed, no such attempt has ever been made to date, not even in my South Carolina felony case. And yet the purported courts of common law general jurisdiction, exercising at least the judicial power of a non-existent state, let alone the judicial power of the United States, go merrily along their way, flouting, if not treasonously ignoring, all of our Creator-endowed inalienable rights secured by the Constitution, and seemingly without a care in the world in so doing. I ain't lying here, and as usual can prove it. And right from the 904, you have actually ruled that filing a petition for a non-statutory habeas corpus 2 days too late by counsel for a death row inmate could not be considered, and he was executed. Coleman v. Thompson, 501 U.S. 722. And they also ruled that actual innocence is not grounds for the issuance of this writ. Herrera v. Collins, 506 U.S. 390. As you will learn from my constitutional defense documents packets, this is because judges, quote-unquote, don't care and don't think they have to care, since they think they can claim qualified, if not absolute, judicial immunity from any claim by their victims. Wrong-o. And the principal goal of my efforts is to make them damn well aware of the fact that they are bound by oath, as are all the local dumbasses and others in the official government capacities, to this Constitution and the laws enacted in pursuance thereof, and are thus totally responsible for their treasonous acts in usurping jurisdiction and denying our rights. A really big deal here is how judges simply assure facts not in evidence, most particularly the consent of the governed. But if we do not object, they will continue to get away with it. As for racial representation comes directly into play. And all of this in a de facto national socialist government in which virtually all government powers have been combined, and one in which not only are states and state citizens not represented, the only ones who have any effective relationship are the New York banksters. Just as I do with 122, I have an available bonus document you can edit and send to your representative to ask about racial representation, in addition to how she or he qualifies pursuant to 122, available on request for information from my modestly priced documents. Please send me an email at youwinnincourt@email.com. You can also ask your rep how she qualifies as a quote-unquote person, as this term emanates today from Section 1 of the non-existent 14th War Amendment, and its meaning is limited to artificial corporate entities whose birthright citizenship can be revoked at any time and without notice by the stroke of a pen of the President, acting as Commander-in-Chief of the Armed Forces. Thank you. Remember to tell your friends and subscribe to my channel.